Okay, I haven't seen you in a while, Mr. Watson.
Good morning, Your Honors. Roy Watson here of Watson and Associates Chartered, representing the appellate, Courtney Worthington Whitner. In this appeal from the denial of coverage on 3 policies of uninsured motorist insurance policy, we call these policies policy 303, 385, and 066. Policy, the lower number 066 is on a motorcycle. Policies 303 and 305 are on automobiles. Policy 303 had provided coverage on 2 policies, a 97 BMW and a Mini Cooper, and they paid the money on those. But there was a 2011 Subaru Impreza that the question is whether that coverage was suspended. Policy 385, there was another 97 BMW, and the question is whether coverage was suspended on that policy. Now, I'm going to talk about.
Can I before as you maybe right at the start, Mr. Watson, I wanted to ask you. The judge here basically said she did not believe your client's assertions of fact, and does that apply? That applies across the claims as to all 3 policies. That affects.
I think so, yes, because
what she said, you know, her husband always signed up for never would have rejected it, and you know, made claim assertions regarding the alleged suspension of the other 2, right? But so when the judge says, you know, I have trouble believing this or whatever, that applied all the way across the board.
Yes, because her declaration testimony dealt with all 3 policies, but and a lot of it that the judge didn't believe was her own behavior, her own conduct, her saying she checked the mail all the time. If I could, I forgot to say, may I reserve 5 minutes for
Sure.
my rebuttal. I forgot. But they're on the car policies 303 and 385. I believe that there is reversible error for any one of 5 reasons here. Number one, the Allstate never did establish that the policy changes were made, much less by whom, that they were made at all. Number 2, they never established that the policy changes were communicated to the insureds, which has to be done. Number 3, they never established that even if a letter showing some change in the policy was somehow received, which they didn't establish. They didn't establish that those changes were initiated by the insurers. And number 4, even if there was evidence on those 4 things, even if they did have an affidavit that they had made the policy change, even if they did have an affidavit that they mailed the change notices, even if they did all that, the affidavit, the declaration of the plaintiff refuted that and
created a fact question.
Created a fact question, exactly. And so I'll discuss those in more detail before going to the motorcycle policy, if possible. Well,
let me ask you another question though too. Is because I got a little lost in the briefing. Did the changes or the suspensions of the 2 auto policies, was that done allegedly through an agent? I mean, an agency, or was it done like on the website by the insured, or did it go through an agency?
Allegedly, by calls to the agent, in which no testimony was presented. You know, when we were
the agent did the agent testify to receiving those calls and then transmitting the information to the insured?
No, and the Allstate representative who testified expressly testified that he did not know what the agent did to authenticate the person. As I was going to say, when we started evidence on how to authenticate a telephone call, you learn either you have to recognize the voice, or you have to call a number that's associated with the person, or you speak about facts that would only be known to a person to authenticate. They didn't do anything to say, and the representative from Allstate, Mr. McNeil, he said he did not know whether the call was to a contact center, the Allstate center, or to the local agent. That's at page 1119 of the record. He did not know whether the caller was male or female. He did not.
All he knew was what was in Allstate's record, correct?
Right, and what was in Allstate's records was not authenticated properly. The letters, there's these letters that were put in with policy change notices and so forth, but they never presented an affidavit that these things were prepared by Allstate and mailed out. Case of Brown versus Reagan that we've cited on our brief, that you can't establish that something was created and mailed just by saying so. The fact of a letter in the file doesn't establish that it was mailed, much less that it's received. So there's no evidence of the existence of the policy change. That the e-agent notes don't show how the insured was allegedly identified. Nobody said I recognize Courtney Whitner's voice, or I talked to her, and this is she said things that only she would know. It's an unauthenticated and inadmissible entry in the record. I'll move to the motorcycle policy for a minute. I'd invite the court to. There was no UM rejection by anybody. There was no purported UM rejection by anybody. And I took a picture of the exhibit. It's on page 1 of the reply brief, and the picture. It's worth 1,000 words, because there's a line for the name of the insured, Stone F. Whitner. It's typed in neatly. A line for the policy number, and then a line for signature, and it's absolutely blank, and then a line for date. And somehow they got this document sent by an agent or somewhere, but it doesn't have any rejection.
In the summary judgment record, is there a signed UM rejection for that policy?
No, there's a blank by the word signature, no signed UM rejection. And just if there was something that had a mark on there that purported to be a signature, there's no authenticating that. I talked about how you authenticate a phone call, but we learned how do you authenticate a signature on a document. Either somebody recognizes the signature, somebody saw it being signed, or you received a document from somebody that you can track how you received it. I remember the old reply letter doctrine. If you mail something to somebody and then they wrote back to you and answered the question that you'd asked in the letter, then that's presumptively authentic from the person. But here there's no rejection by anyone, and if there was, counsel, Ms. Silver argues that this was electronically signed somehow, but it's not, because there is a place for an electronic signature. But just again, to suspend the disbelief and say, suppose there was some mark there. They have not established how that mark got there, from who that Stone Whitner authorized it. There's no electronic signature or any other type of signature there. Ms. Whitner, in her declaration, she said, even if it had a signature there, it could not have been from her husband, because it reflected that it came from an IP address, and her sworn declaration says that IP address was not associated with any computer that my husband had access to, any cell phone, any laptop, anything of that nature. It came from an IP address that says evidence was either in Orlando or Seminole somewhere, but no one associated that IP address. Nobody said this is an IP address that we recognize came from Stone Whitener. He was at work in Palm Harbor when the thing was allegedly sent.
And this
Okay,
was this was the IP address from which the signed or unsigned waiver was sent.
right. Right. The IP address, and he didn't have access, and there was somewhere, although it's not on the rejection form, somewhere there's an allegation that something came from Stone Whitener from the email address stonewhitener@hotmail.com, but there's no authenticating that as being his email. Nobody said that was that he came into an agency and said that's my email address. And Courtney Worthington in her declaration said he did not use that email address. That was not an email address that he used. So as I say, I'm trying to say that because even if we accept somehow that a complete blank on a form is somehow there's an electronic signature, it was not associated with Stone Whitener in many ways. It wasn't from his email. It wasn't from a computer that was associated with him, and nobody testified that to any facts that would say he sent that. Going back to the other two policies, as I said, we have all of these exhibits. There were 11 exhibits filed in support of the motion for summary judgment. None of them was authenticated. Nobody said this is a true and correct copy of a policy declaration change that was made on this date and mailed to the Whiteners. I cited a pretty lengthy quote out of a couple of cases here. There's two cases, Brown versus Regan and Savoy versus American Platinum Property and Casualty on page 43 of our brief address this situation where you have some policy documents here. In that case, the corporate representative testified that various letters were mailed. Here we don't even have an affidavit, a conclusory affidavit that various letters were mailed or policy changes were initiated. The fourth district in that case said that you have to either present evidence of quote personal knowledge of the mailing, 2, evidence of a routine mailing practice that was not done, or 3, provide records of the mailing such as a log or return receipt. So there's no evidence that these were sent, and there's no evidence that they were received and no presumption that they were received because there was no evidence that they were sent. And Courtney Worthington said, I check the mail every day. I was in charge of doing things in the insurance end in our family, and I never received these documents. And even if there was some evidence that they were received, or even there couldn't be conclusive evidence that would entitle them to summary judgment, there was no evidence that these changes were initiated. That was about the first thing we talked about, that nobody authenticated the voice of the insured or the contact with the insured. And we've got cases that say that where even if the policy change was made and had been delivered, if it was not initiated by the insured, it's not valid to bind the insureds. So there's, as I said, there's many reasons why summary judgment was improper here, and there should be, actually we should have gotten, I should have made I think my own motion for summary judgment had been denied. I should have done a cross appeal and asked for my denied summary judgment to have been granted on these issues, but we'll leave it for the jury to decide factually these issues. But I don't think I need all my time unless there's any further questions from the court.
You're right at your 5 minutes left as it is. So, thank you, Mr. Wasson. Ms. Silver.
Good morning, and may it please the court. Based on the overwhelming and unrebutted evidence, the trial court granted Allstate summary judgment in its favor, and this court should affirm. I'm going to start with what I feel is the most egregious argument made by Ms. Whitner, and that's the policy ending in 066. And that covered two motorcycles, including the motorcycle that Mr. Whitner was on at the time of loss. When you look at the filed signed, electronically signed rejection form, it is absolutely not blank. It has name, Stone F. Whitner in all caps. And Mr. Wasson intentionally leaves out and cuts off what's below that on the electronically signed form because it says signature. And immediately to the right of that, it says signed and his name again, Stone Whitner. And then below that, it says date and it says 2015, 06/22. And then it actually has the time that he electronically signed it. And then also to the right of that, it identifies the policy number and ending in 066. So to make the argument that there is not a filed electronically signed rejection form for the policy ending in 066, I felt had to be addressed first and foremost. As far as the evidence that was presented in this case and the argument that it was unauthenticated, the Whiteners frequently used, almost exclusively used an agent. And the name of that agent was Tampa Bay Insurance Agency, I believe. And so what we submitted as evidence, part of our evidence, was those actual e-agent notes for when the Whiteners had conversations with their agents at Tampa Bay Insurance Agency. Luckily, Craig Arndt, who is the owner of that agency, actually signed an affidavit, and the affidavit wasn't for purposes of submitting substantial evidence pursuant to 1.510. This was for the business records exception. So he was attesting to these e-agent notes and that they met the foundation for the business record exception because he is the owner of this agency. These are the e-agent notes that they keep in the regularly conducted business. And so when you look at the e-agent notes that were part of our evidence, Courtney is frequently calling. They identify her by first name. Stone is frequently calling. They identify him by his first name. And if you look at that page, as far as identification and authentication, there's a page that says, what's their name? Courtney Whitner. What's their address? What's their telephone call? And so these e-agent notes actually show, as opposed to what Ms. Whitner is arguing, that these are some unilateral changes in the policy, it actually shows Stone and Courtney calling into their agents asking to suspend various coverages under their three policies. And so what then bridges the gap is we had the testimony of Timothy McNeil, who works for Allstate, and he is the manager of call centers, and he testified to his training and experience as well for agencies and how agents handle these phone calls. And so what he testified to is that there is an authentication process for when these insureds call into their agent. And we actually know that process was done because it actually ends up on their exact page for Tampa Bay Insurance, because they had to identify their name. They have to identify their policy and their date of birth. Otherwise, they're not going to end up on their page of notes. And then he said that after an insured initiates this change, because it's never an insurance company that's calling that says, hey, would you like to suspend your coverage and pay less of a premium? That's just not what happens. So then in automatically what happens, and he testified to this based on his training and experience, is that there's a system called Alliance that Allstate uses. So what happens is Allstate sort of shares this information with the agents. And once an insured calls in, makes a change to their policy, that is updated automatically to Allstate through Alliance. Allstate then generates the policy change documents, which was submitted in this case as our evidence. The policy change documents actually show the policies that are in effect after the Whiteners make these changes. It shows that there's no premiums being paid for the subject Subaru Impreza under policy ending in 303. And that actually occurred in 2012. And there's an e-agent note that also backs that up, that it was initiated by the insured. And then it also shows that under policy ending in 385, that was a 1997 BMW, that policy was not in or that BI and were suspended, I believe, since 2014. And also to back that up, it corresponds with an e-agent note that it was initiated by the Whiteners and the insured. And so as this court has stated, and which was affirmed by the Florida Supreme Court in the, I think it's called the Channel case, we look to the policies that are in effect to say what coverage is there for the cars at issue. And as this court also stated and affirmed by the Florida Supreme Court, we don't look to how many cars there are. We look to what premiums were being paid for or BI for which vehicles. So under 303, there were 2 vehicles where BI and were not suspended, and it was a 100K stack. So Allstate paid $200,000 under that policy. However, when you looked at policy 385, BI and were suspended by the insured. The policy documents that are generated as testified to, as number 1, proven by the e-agent notes, which were authenticated as the business record exception by Craig Arndt, owner of that agency. And then number 2, are documents showing the actual policies in effect, which were authenticated by Timothy McNeil. And I just want to note that the trial court has wide discretion in admissibility of evidence, and there has to be an abuse of discretion in order to overturn that trial court's determination that the evidence was admissible. Then you can see that there was a suspension of the BI and the ending in policy 383, which is why Allstate never issued any money for that policy. Looking at this declaration, it is not surprising at all that the trial court found that these statements were conclusory, not supported by any fact, not supported by any evidence. By the way, these statements, these declarations were made more than 10 years after each car was suspended. So Ms. Whitner, now Vaughn, remarried, is making these declarations for actions that happened or alleged actions that happened more than 10 years ago. The court agreed that Ms. Whitner cannot make statements on behalf of her late husband. Not only does that violate a confrontation clause for me because I was unable to cross Mr. Whitner, but things that she says are so far-fetched, the point of, I know Mr. Whitner never used a computer for non-business purposes. There is no way she can make that statement or declaration on behalf of her deceased husband. Statements like, I always checked the mail. How can she state that her husband never checked the mail? I mean, those are just a few examples of really how far-fetched, and the court agreed these declarations were, again, made more than 10 years after these suspensions are initiated by the insured. Further, there's absolutely no evidence within those declarations to back this up, right? So, well, what evidence have you provided? There was no evidence provided in support of these conclusory, self-serving statements by Ms. Whitner. In fact, the evidence really refuted every single declaration that was within that declaration because of the fact that we have the e-agent notes, because of the fact that we have these policies luckily showing these changes since 2012, since 2014, that no premiums for BI or were being paid. And then I want to turn now to 066, because we actually had Craig Hall's testimony to support this electronic signature. I want to, again, really briefly go back to the e-agent notes, because when you look at those notes, you will see Stone Whitner actually calls in and he says, hey, I want to purchase this Honda. And then a couple days later or a week later, he purchases the Yamaha, right? But he calls in about the Honda and then documents. He's the one that's in charge of them. And so he explains that there's an audit trail, there's an audit trail for this e-signature process. And so I know Courtney Whitner says Stone Whitner never used this email address. Well, I don't know how she can make that declaration. And number 2, I think it's very clear that there's a link, obviously, between this rejection form because of the fact that Stone Whitner had to use that email. And what was the email? It was his name, Stone Whitner. But I want to go through that testimony because it's important as far as the e-signing process. So the audit trail shows that he has to use the email address stonewhitner@hotmail.com, and he has to use a password to actually log into my account. The audit trail reflects that the customer used a 10-digit IP address, and that ends in 254. And it's very important to point out that Stone Whitner worked in Pinellas County. And the IP address identified Seminole, the city of Seminole, as a general location of where this this rejection form was signed. So within the same county, it's not going to be the exact location. It's going to be the general range of where that electronic form, that rejection form was signed. And it's in the exact same county of where he works. It shows, the audit trail shows the customer reviewed the UIM rejection form on June 22nd, 2015, and it gives an exact time. It reflects his signature date, and it reflects the time with exactly as stated in the rejection form that we filed in this case, entitling us to a conclusive presumption of rejection of coverage. It shows when it's completed, and it shows when he submits the package of all e-sign documents. So to state that there has been no evidence of authentication, that this form was signed or electronically signed by Stone Whitner is a misrepresentation of the evidence that was presented to the trial court in this case. And I do want to cite to a statute that Mr. Wasson actually uses, 668.50 subsection 9, and it states an electronic record or electronic signature is attributable to a person if the record or signature was the act of the person. The act of the person may be shown in any manner, including a showing of the efficacy of any security procedure applied to determine the person to which the electronic record or electronic signature was attributable, and also determined from the context is Part B. We have absolutely met our burden by having the testimony of Craig Hall, who testified as to this audit trail, who testified as to the email used that showed that this was actually e-signed. We actually have, again, the rejection form with his e-signature there, and it is absolutely not blank. And then I do want to address this argument that it was never mailed, it was never received. This is a suspension of MBI on behalf of the insureds initiated by them. This is unlike the Keys case cited by Mr. Wasson, in which the insurance company actually admitted we did unilaterally and erroneously suspend this coverage. That's not the case here, and Keys does not apply. This is not a notice issue, as Mr. Wasson argues in his brief and responses, pursuant to 627.728, right? This is not like a cancellation or a non-renewal where we have to prove that it was mailed and that it was received by them by U.S. proof of mailing or certificate of service, something like that. This is a suspension that's not covered by that statute. There's absolutely no case law that says a suspension initiated by the insured, as shown by their e-agent notes, as shown by the actual policy documents in effect that were admissible pursuant to Mr. McNeil's testimony. This is not a case where Allstate has to prove or show pursuant to 627.728 or any other case law that I'm aware of that it had to be mailed and received by the Whitners, although we do believe that the documents show that it was mailed, but we do not have to show notice pursuant to that statute. Our evidence was authenticated pursuant to the business record exception. And again, the trial court does have broad discretion in determining which evidence is admissible. And the trial court found that it was. And therefore, we would ask this court affirm the trial court's ruling on Allstate's motion for summary judgment. Number one, under 066 for the Yamaha that he was driving at the time of the accident, he rejected on that form, on that policy on June 22nd, 2015. Number two, under 303, $200,000 was properly paid for the two vehicles where the Whitners were paying BI and premiums for two vehicles and not paid on the third vehicle because it was suspended, the MBI, as of 2012, initiated by the insureds. And then as to 385, of course, BI and were suspended on that 1970 BMW, I believe, as of 2014. And as this court has stated, we look to the policies to see what premiums were paid when we determine what coverage is owed. And
Ms.
there were
Silver,
only, yes, sir.
I want to ask you a question. The judge here said, hey, I don't believe Miss Whitner Vaughn, I guess is her name now. Would you put that in the context of the summary judgment, federal summary judgment standard? How does that fit?
Well, I would put it in the context
And
of,
in the facts of, the evidence in this case and the federal summary judgment standard.
right. So I would absolutely point to, I think my most important case law pursuant to CELO text is that, let me just find it. when no jury could reasonably believe that at each instant, Allstate unilaterally suspended coverage for the subject vehicles, as Ms. Whitner would have the court believe. And that, well, I believe the federal rule is that when no reasonable jury could believe these, I guess, disputed facts, then it's not proper to find in the light most favorable to the non-moving party. And I believe the proper rule that we should look at is, I'm sorry, just give me 1 second because I had it highlighted because I loved it.
Well, then I definitely want to hear it.
Okay. Because on motion for summary judgment, when opposing parties tell two different stories, one of which is blatantly contradicted by the record so that no reasonable jury could believe it, a court should not adopt that version of the facts for purposes of ruling on a motion for summary judgment. And I believe that the trial court properly agreed with that sentiment and that rule, that this self-serving, conclusory, no evidence-based declaration was blatantly contradicted by the record and no reasonable jury could believe it. And that concludes my argument. I really do appreciate the time. It's a privilege to argue in front of you all. Thank you for your time.
Thank you very much. Okay, Mr. Watson.
Yes, first,
Rebuttal?
I've never been accused until today in 44 years of practice of tampering with the evidence. Ms. Silver said that I cut something off that was relevant to this case, and I'm very shocked by that. And I'll ask the court, please, first check the reply brief where I took a picture of the thing as it
Mr.
is in the
Watson,
record, and it goes all.
Mr. Watson, Mr. Watson, I think there are, the way I read the record, for whatever it's worth, is there are 2 copies in the record of the policy for 066. It was first entered into for the 1 motorcycle, then the 2nd motorcycle was added to it. The way I read the record was that when it was entered into for the 1st motorcycle, there was an affirmative rejection of the coverage. And then nothing changed when the 2nd motorcycle was added.
That's
So
wrong, Judge. That's wrong. The first motorcycle, and go to page 1359 of the record.
I'm looking at page 186 of the record. There is indeed a signed copy of the rejection for policy number 066. Later in the record, there is an unsigned copy of the rejection for the policy 066. There are two versions in the record. So I think, to the extent for what it's worth, I don't attribute this to an affirmative misrepresentation on your part. I think there are actually 2 versions of the policy in there. And so I appreciate your concern about what was said, but I think as a practical matter, I don't think it's something that you need to spend your time on rebuttal.
Thank you. All right, thank you, Your Honor. And I'm sorry if I misunderstood, but there's been no authentication of that signed one as having emanated from Stone Whitner. And just real quick on my points, counsel argued that the record showed that Stone Whitner called in at one point. There's, you've got to say, and I recognize his voice, or I know him. There's no authentication of the voice. She argues that there was an authentication process. She doesn't say what that process was. When we open an account, they have to call us back and send us a secret code to our cell phone numbers or something of this nature these days. And my last point I'll make, and that is the Arndt affidavit that allegedly establishes what it says. It's inadmissible under this court's 2023 case of Greenspire because he said it's based upon his knowledge and belief. And where you add that and belief, it renders it totally inadmissible, and the court should reverse the summary judgment. Thank you, Your Honor.
Okay, thank you both very much. In order to leave our virtual courtroom, you need to click the leave button, which should be in the lower right-hand corner of your Zoom screen. And then you'll be gone. Thank you. And that is our last case on the docket today. So we are adjourned.